Yeah, but what you were saying though?
Yeah, but as far as with that Meach shit, you know what I mean? How they did, you talking about, right? So that shit we was talking.
Yeah.
Yeah, but like, it's just like, you know what I mean? Certain laws and statutes and all that shit can change. So that shit changing in my favor. But you still gotta continue to raise the awareness around the shit that they did. You know what I mean? You already know I was unlawfully convicted. So I'm in the process of still fighting that shit right now. You feel me?
Yeah. And so,
Came back on.
go ahead.
You know, I was just saying, like, I got back partially on my appeal, but it's still issues. You know, that still got to be addressed by the higher court, the Supreme Court, because the issue that, you know, the issue we've been talking about as far as my constitutional right to a speedy trial.
Right.
You already know that's a Sixth Amendment violation. You know, it took them almost 7 years to bring you to trial, 6.5 years.
Right, that's a fact.
I mean, for them to use the fact that because I was on bail on house arrest and because I was making music and selling my music, making videos showing off my ankles, they used that as a to deny my appeal, but they failed to address the actual, you know, the merit of the claims. You know what I'm saying? Like they didn't address the facts in the law. You know what I mean? As far as denied it, so. So it's at a point to where I got to take it to the Supreme Court in order to get them off. But you know, it's crazy when they violate somebody's speedy trial rights because as you know, you already know about the Khalid Browder dude that committed suicide on Rikers Island.
Right, from New York, right.
Yeah, from New York. You got to deny him his constitutional right to a speedy trial, and his lawyer played a part in helping deny his constitutional right to a speedy trial because you know an attorney, this ain't even the law. But it's just what they should change the laws. They hold you accountable because your attorney don't search you to a speedy trial. So at the end of the day, an attorney got to pass the bar in order to become an attorney. You know, your attorney know about a speedy trial. The client don't know about a speedy trial because he's not off the rip. He's not to the law. He don't know the law. You know what I mean? So he studies law. So if the attorney basically helps the courts violate his constitutional right to a speedy trial by failing to raise it. That's ineffective assistance of counsel. And the same thing on my behalf. I actually submitted a letter to the court before I went to trial. I submitted a letter to my previous attorney stating that he was violating my right to a speedy trial because he never raised the issue. But he knew that I was at the time that I wanted a speedy trial. You know what I mean? But he failed to raise that issue. He raised it late in the game. And that's another thing that the court held against me. They held against me the fact that they claimed that I waited 4 years to raise my right to a speedy trial. Well, I didn't actually want a speedy trial.
Right.
It's not true. My attorney knew I wanted a speedy trial. I just didn't know at that time because I'm not a lawyer and I wasn't studying the law at the time. I didn't know that I had to go in that courtroom and put it on the record myself. And really, my attorney's supposed to put it on the record, but in order for me to preserve my rights, I would have had to know and done it myself. Right? You know what I'm saying? So that was my reason. Once I finally found out, I found a letter to the court, but the higher court, once again, they overlooked that letter on my appeal, bro. They never addressed it, and that's in the appendix of my speedy trial. You know what I mean? So for them to overlook that is something how they know something wrong. You know what I mean? That's a point of I think need to be addressed. You know what I mean? Like an attorney should be held accountable for violating, you know what I mean, a defendant's constitutional right to a speedy trial because you got a Sixth Amendment right to effective assistance of counsel.
Right,
you know,
right. That's a fact.
The Supreme Court case that deal with that is called Strickland versus Washington, where it shows that you require to have reasonable assistance of counsel and effective assistance of counsel that you don't. It's a Sixth Amendment violation, and that's an automatic reversal on those grounds alone. You know what I'm saying?
That's a fact. That's a fact.
You know what I mean?
And what's that case they can refer to see?
The case they can refer to is right to see what happened with my issue or whatever.
Uh-huh.
Just that way. any, you know what I mean, law, any site where you can look up case law. I know it's out there for the people who's not familiar with LexisNexis, familiar with Westlaw. They can go on Google Scholars and just put my name, Kenneth Petway. I mean, or United States versus Kenneth Petway, and look at the most recent decision. And it's actually in the Buffalo News. Like the Buffalo News touched on it a little bit when I got relief on my appeal just recently. They touched on my attorney trying to get the case completely vacated on speedy trial grounds, and it even say why the court denied it, and talk about how because I was in music and showing an ankle monitor on video and I wasn't prejudiced. There's 4 things that you gotta meet in order to show that your constitutional right to speedy trial is violated to the delay, which is one prong, and the second prong you gotta show that the reason for the delay, meaning who was more responsible for the delay in the case, was the defendant or was it the government?
Mm-hmm.
That you asserted your right to a speedy trial, and then the fourth prong is that you was prejudiced by the delay. You know what I'm saying? I met all 4 of those senators, but the court, they felt like it weighed more in favor of the government. That's what they ruled on, you know. So the next step is to take the issue to, you know what I mean, the Supreme Court. That's just one of the issues, though, you know what I mean? So, you know, people always talk about it.
Right,
That's
definitely.
the same issue. Like, my case should have never even went to trial. And not only that, bro, the judge on my case that was initially on my case, he handled my speedy trial motion. I filed 2 different speedy trial motions in the district court. You know what I'm saying? So the first one, my previous attorney, he filed it was like, the way he filed it, I feel like it was kind of, he filed it knowing that it would deny it the way that the class, you know what I mean? Just because I put that letter into the court, so now it pushed up against the wall. He had to file it now because now the court see that I'm on the speedy trial. But he waited, he still delayed. He waited about 8 months later, maybe 8 months later, he even filed it and raised the issue to the court. You know what I'm saying?
Mm-hmm.
So now, once there was a conflict of interest on my case, I had to hear.
And that's
They assigned me an attorney after that in February of 2018, and I went to trial 3 months later. But when I went to trial, that is the new attorney in my case. He filed his trial motion. He really put it together well. You know what I mean? I was very, very well on it. I helped him with a lot of the issues. I walked him through the case. You know, the attorney coming on a 6.5-year case. And you 3 months to prepare, that's a whole, if you gotta try to prepare for trial and file a motion, that's dealing with things that are 6 years old, you know what I mean? So I have to try to bring him up to speed on everything.
right, definitely. So, so what he's saying, y'all, is basically, he been trying to go to trial during the proceedings of the case. He was trying to go to trial, and while he was trying to go to trial, he was denied trial, basically based on, you know, like them just basically keep on adjourning it and doing different things to make sure that the trial don't happen. Yeah, superseding indictments, basically slowing the proceedings of the trial down so they could get as much time to fabricate it as possible. When if they already had a case, he basically saying that if he was trying to suppress the evidence, they were supposed to suppress the evidence when he asked them to do it, instead of prolonging the case with a bunch of frivolous adjournments and superseding indictments and just prolonging the process. So if y'all had, so he basically saying that if they had a case, then they was supposed to prosecute right then and there. It don't take 7 years to. Go ahead.
It's not. The Supreme Court also hold that, like how Meach was explaining to y'all, if they had the evidence and they was ready to go to trial, they supposed to show that on the records they're supposed to state their readiness. I mean, the government, and then it's not up to the defendant to bring himself to a speedy trial. It's up to the government and up to the court to the speedy trial.
Right.
Parker versus Winkle is the case that deal with a constitutional violation of your speedy trial. Like, you know what I'm saying? That to lay out the foundation of what has to be done in order for you to get a speedy trial, and lay out the foundation of when there is a violation of your speedy trial rights. And There's also a case in our circuit, which is Second Circuit. That's the circuit that I'm in. It's called New Buffalo Court Station versus I think United States. And that deals with the government. The government and the court have the obligation to bring a person to a trial. So that way, let's say that it took me 4 years to raise my right. That's the way against my claim.
Right.
And that's what we raised. That's the issue we raised. And not only that, like Mr. stated, we filed a trial motion, but the motion was filed, I think, in May, at the beginning of May of 2018. I went to trial in 2018. My loops in 2018, right? So the judge was supposed to answer to that motion before I went to trial, because the point is a speedy trial motion.
Right.
Waited to hear. They assigned a new judge on the case, so this new judge really didn't know about everything that was going on. So I can't fault the judge that they put on my case right before I went to trial. The actual judge that took the speedy trial issue, he assigned a new judge on the case, because if he had them, they would have violated my speedy trial rights even further, because they would have to adjourn my trial for almost another year.
Right.
Instead of doing that, he put another judge on the case, but this judge was not aware of the speedy trial issue until we brought it to his attention. And when we brought it to his attention, he wanted to answer the speedy trial motion, but when he contacted the other judge told him, no, he gonna hold that motion and he's gonna answer the motion. So he wanted to wait to hear the evidence on my case in order to answer the motion, and that's prejudicial right there alone, I believe. You know what I mean? Because that's evidence that's being presented against me. That's evidence of people coming in there, hearsay statements, making up stories. And so after he hear all this evidence, why would he grant me a speedy trial motion? Why would he grant me a dismissal on speedy trial when he already heard the evidence? So he didn't answer my motion until about a week before I was to get sentenced. And I didn't get sentenced until October of 2018, about June, July, August, 5 months after I was convicted. So he waited 5 months till after I was convicted to finally deny my speedy trial motion. You can look that up on the computer as well. If you look up my name, all of my motions, and you got to go on something like Google Scholars in order to look up actual opinions from case law, unless you got access to LexisNexis or Westlaw. So if you want to, find out more and read up on things yourself, me and Meach, we gonna put some links up. I'm gonna send them some documents so y'all can check it out. And see how I was denied and how everything went. But
and also, like all the people that want to help, it's a petition going around, and it's gonna be another petition that's correct, because there's several issues that he's trying to raise, and he got a lot of valid issues that he is trying to raise. So we gonna continue this campaign, Justice for Jay Batters, get my man back on the street, get him home to his family, get him home to his kids. And again, you know what I'm saying, y'all could go to @JBatters on Instagram and sign that petition. The link is in the bio. I'm almost at 1,000 signatures, so we just trying to get him back home to his family. You already know.